All right. Today we will take a bit of a different approach, Mr. Mangwato. But first of all, we need to explain to colleagues that apologies that we have a continuation of the battle. I think it was the career one with Auxiliarato, and she had an emergency, I'm told. So she will have to continue her session next week. But I also indicated to Mr. Mangwato that given that I had also mentioned at some point that we need to take educators through POPIA Act just as an awareness, I just say to him, let's replace Auxiliarato session today with POPIA. We are still firming up our, we are looking for somebody an expert to deal with personal finance for educators. We are in talks with, I think, two or three people. As I indicated at some point in time, we did not want to bring insurance companies and banks because they end up selling their products, and rather than capacitating us on how to handle our personal finances. So there is a person I'm actually supposed to talk to today, and also Johnson has been doing his own communication with someone else, and hopefully we will win in that regard. But then today we said, let's take our time to just go into a little bit of law. And we will try by all means to be as practical as possible. It's quite a complex subject to teach in a virtual platform, but we will try our best. What we will do is I will have to do a lot of illustrations. I have taught law, and it's one of the subjects that I teach even at university level. So the way I have taught it before has never been on a virtual platform. And you will see the reason why I'm saying that as we proceed through it. I'm going to show a presentation now, and I will load so that you are able to see it. And we will work from that presentation in order to tackle the subject. But what I'm going to do, colleagues, good afternoon to those that are joining, and welcome. Mr. Mangwato has already welcomed us, and you're welcome to today's session. It's a POPIA presentation on the Protection of Private Information Act, which has been enacted and also signed into law by Parliament and the President. And it was the implementation did not happen immediately, and we were told that last year, the other year, 2020, organizations must begin to prepare for the implementation of POPIA, because it's very important for us to begin to protect private information. And then we're given 1 year grace period within which to start implementing it. And July this year is the year, it is the year in terms of which such implementation must happen. And that is why we thought, let's do some awareness of this so that we can be assisted. So what I'm going to do is I will try and illustrate. I will see if it's going to work on this platform. But my presentation is basically about POPIA awareness. But I'm going to spend the first maybe 30 minutes or so just going into general principles of law because it's almost impossible for me to be able to present on POPIA without giving a bit of background into law. So I'm just thinking to myself, maybe I will have to shift and go into a Word document. I'm just going to check if this one will be favorable. I think let me rather use a Word document. I think it will serve me better. So the first thing that I will have to start with, before I have done any teaching on law, I've always started with the basic principles so that we are able to be on the same page. I do not want to assume that we are all in the same page regarding law. So I'm going to start at what is law, and I'm going to welcome views from the platform. Let me just increase this. Please confirm to me if you are able to see what I'm typing there.
It's visible.
All right, so let's start with law. What is law? Can anyone give me their own definition of law? Others can type their definition in the chat room so that we can tackle this thing. Anyone? Anyone to share their thoughts? What is law? I won't be able to see the chat room, so anyone to share their thoughts? What is law? What comes to your mind the moment you hear the word law? Okay, I see Glenda has already typed, and I also see Maureen. Maureen, you can unmute and share your thoughts.
Good afternoon, and thank you very much. Let me start by saying law is the systems of rules or a system of rules that a particular country can take in order to ensure that the people are governed, to ensure that people are not doing as they wish, but follow a certain practice that will ensure that everybody do what he or she expected.
Okay, I see I picked those few words from Maureen there to say it is the manner in which a country ensures people are governed. I've also picked from Glenda. I'm gonna just try and, okay, let me try and reduce this. I think 28 will be fine, or let me just put it 36. All right, I also saw Glenda. Okay, Glenda said it is, the law is the legal decisions by a country, correct? All these are correct. Okay, any other view? Any other view? Okay. Because it's very critical for us to understand these basic principles as they help us. I'm not sure, do share, but please, colleagues, know that I won't be able to see your hands, so just unmute and share your thoughts.
Okay, good evening, colleagues. I think law is something that you cannot do as you wish, and also it is regulation and also policies that we need to follow so that we cannot find ourselves in jail or sometimes guilty on doing it.
Thank you so much. So it is something in terms of which we all cannot do as we wish. We have to follow certain guidelines. All these views are correct. And I'm going to then supply the working definition that I've worked with for a while to say law refers to the rules and regulations. rules and regulations that govern the behavior of a society. So every society has to have certain rules, and I think everyone here, including colleagues who have spoken, they have given something to do with governing legal decisions made by a country, and things that we need to do. So it's the rules and regulations that govern the behavior of a society. And look at a number of things that come in there. Rules is one of them. Regulations is one of them. And then the item govern, it also features in there. And then you hear the word behavior. And then you also see the word society. So a society has to have a certain set of rules that govern the way we behave. Otherwise, if we are left, I think Dudu has brought it well to say, if everybody is to be left to do as they wish, there will be chaos in society, and society will be ungovernable.
I can hear people talking now.
You can hear us, right?
Yes, yes.
All right, awesome. So every society has to have a set of rules, a set of regulations in terms of which their behavior or our behavior is governed. Otherwise, we are unable to have a safer society, and we are unable to have a society with law and order. So law is basically that. So these rules and the regulations are further divided. So we can have then the behavior of a society in certain segments. So we will have a segment of how society must behave, e.g., on the road. Society must behave in terms of in relations with each other, and then workplace rules. Then we think of even rules within the family. So essentially, this behavior, which must be governed, is governed in terms of a certain set of rules that are developed, which are specific to the behavior we are talking about. So we behave towards each other, we behave towards the state behaves towards us. Essentially, you can divide law into two major parts. You can divide law into what we call private and public law. And this, we must caution to say, we do this loosely because usually that dividing line is very thin. It's a very thin line and very difficult sometimes to differentiate. So you will find there is public law as well as private law. Very difficult to demarcate and differentiate. But let me start with public law. Public law refers to laws that govern the relationship between the individual and the state. So public law governs the relationship between the individual and the state. Let me put this into landscape. I think it will be better that way. We can have more space. So essentially, public law governs the relationship between the individual and the state. When we say the state, we are referring to the government. And the government consists of three players, which is the parliament, the judiciary, and the executive government. So the relationship between the individual and the state is such that the individual must behave in a certain way towards the state, and the state must behave in a certain way towards the individual. Take a very good example of such law. Such law includes criminal law. That is why at any given point in time, when you hear that a person has committed a crime, the crime is always committed against the state, even if it is not the state who has been injured or who has been robbed. It's always the individual who has committed the offense versus the state, because the state is the one that is in charge of all criminal law. So criminal law is one of such laws that governs the relationship between the individual and the state. And it's very important for us to see it in that way. And please note that if you look at, for instance, it will be very difficult for us to include the Constitution in public law without also including it in private law. But I will give you reasons for that. For example, section 33 of the Constitution is critical for this discussion. And I will tell you why in a short while. So in a certain way, we also can include in the relationship. Hello?
Can there is a hand from Mr. Untitled Nguna.
All right, Mr. Nkuna.
Hello. Okay.
Mr. Nkuna, we can hear you.
Yes, sorry, I'm late. I don't know what I just did, but I was not raising my. Sorry about that.
Oh, I think it could be just a technology issue. Thank you for that. We are discussing POPIA, but I'm giving a background to law generally so that we're able to flow together. So the Constitution section 33, every one of you needs to know it off heart. And then you need to also know administrative law. Administrative law, it also governs the relationship between the individual and the state, and it emanates from that section 33 of the Constitution Act number 108 of 1996. You will see why I'm talking about this. Then the private law
Am I the only one who's not hearing Mr. Boucher? I'm not sure if ever.
No, you're not the only one. I've also lost him.
All right, can you hear me now?
Yes, we can hear you now.
Yes, we can.
Just give me a second. Let me connect my physical internet line. Probably it can also assist. I think I'm told the internet line doesn't have issues. All right, I've connected it. I hope everyone can hear me now.
Yes,
yes, we can.
Thank you so much, Sean. Let me proceed. So I was saying examples of public law is the law that governs the relationship between the state and the individual, examples being criminal law, constitutional law, and there's a thin line because constitutional law, it also applies to private law, administrative law, among others. Then when it comes to private law, it is the law that governs the relationship between individual and individual. Like, for example, the law between e.g.
Mr. Boucher?
Yes?
I'm
Can you
not
hear
sure.
me?
Yes, we can hear you, but I no longer see the presentation. I think someone just uploaded his or her screen, or maybe it's my network. I'm not sure.
I think somebody kicked me out with their
It's
screen.
in Shamiela Adams. Can you please?
All right, Shamiela, I think Shamiela might have clicked some buttons. Shamiela, let me see. All right, but I think people can see me now. No, we are forever patient because we know technology issues affect all of us. Even me, sometimes it makes me look stupid, but we learn every single day and ensure that we're catching up, so we don't punish anybody for things like this. All right, so we were saying, so law is divided generally into two parts. So the private law is, for example, the law between husband and wife, child, parent, the law of property, the law of persons. The law of persons, for example, it determines who is a person. There are certain people who cannot be. I'm even incorrectly to say certain people. To say there are certain things which cannot be regarded as a person. And I'll give you a very good example. There is a law, and this one troubles first-year students in law school, to say that a fetus which is unborn is not a human being. The debate has gone on for ages. And they will say that the law of persons determines who is a person and who is not a person. For instance, a fetus which is in the womb can never be regarded as a human being at law until it is born alive. And the only time it will be regarded as a human being is if any injury, for example, may have happened to this fetus while it is in its mother's womb, such that then it is born alive, and injuries that were caused while it is in the womb, they continue to then manifest when it is born alive. It is only on that circumstance that a fetus can be called a human being. Otherwise, as long as it is in the womb, it remains a substance and not a human being until it is born alive. That's a law of persons bordering on private law. We also have company law. Yes, Ntate Mangwato? Ntate Mangwato?
We sometimes lose you.
You're losing me. I wonder, Johnson. I don't know, because I'm in the office and just trying to see if we can station this laptop maybe.
I guess Mr. Boucher, it's Mr. Mangwato's network connection.
Yeah,
it could also
be his connection from where I'm standing.
That's right.
I can also hear properly. Mr. Mangwato, please check your connection. Thank you.
Thank you. So the law of persons, you also have the law which we call the law of delict. When you go in the English jurisdiction, they call it the law of torts. And it's a law that governs issues such as injury. For example, laws such as the law of defamation, it comes under the law of delict. For example, in South Africa, I think it should be 1903, a case happened where in the railway system, someone called someone macaroni bastard. And this person took the other party to court to say, you defamed me by calling me macaroni bastard. And when the matter came before the court assessed it. And that's where some of the rules regarding defamation were formulated to say that when such communication is made, it must be of a derogatory nature, number one. Number two, it must be communicated in the presence of a third party. Number three, that such third party can form an opinion which is of such a nature that it damages the image of the person about whom such communication has been made. Then defamation of character would have happened. But then the court dismissed that case because they learned that these two people, they asked the other one to say, what is your context? Where do you guys work? They realized that they were working in the same organization. And they says, have you ever called him names yourself in the work environment? And he said, yes. So he says, so you, because today he called you macaroni bastard, and it sunk so deeply that you decided to prosecute, but you have called him things also in the past, and he never took you on. So it was regarded as these things, we say them to each other in the work environment by virtue of being in the same workplace and in industry. So it's an example of a law that governs the manner in which individuals behave towards each other. It does not necessarily mean that we have a license to insult each other because we work together. But that law is applicable in that regard. So there is a law of property, company law I've mentioned, law of property, patrimonial law, and so on and so forth. Now, let me move to something else. I want to, for example, highlight for you Section 33 of the Constitution. It is one of the laws that you can utilize a lot. Section 33 of Act number 108 of 1996, which is essentially the Constitution of South Africa. So this Section 33, you need to know it off heart because it applies to many situations. It is a law that governs the regulation of the power of the state. And in terms of this law, it is the one that also then gave rise to PAJA. PAJA, which is essentially regarded as the just administrative action law, which says everyone has a right to administrative action that is lawful, reasonable, and procedurally fair. And therefore, any decision of an administrative nature made by a public functionary must be subject to review to the extent that it must be lawful, reasonable, and procedurally fair. Schools have also been affected by this law. For example, when you make certain decisions, be it when you kick a child out of a school or many other administrative decisions, because you are a public functionary, because you are performing a public service, you need to then ensure that everything you are doing is lawful, reasonable, and procedurally fair. We can also bring POPIA right here. POPIA, we can bring it here because it governs the relationship between individuals and individuals. And when we talk about individual to individual, there are two kinds of individuals that exist in this earth. Individual. So there are two kinds of individuals. There is a natural person and there is a juristic person. Natural person is like you and I. Juristic person is like a company, an organization, or an entity. So a school, for example, is a juristic person. It tends to act individuals, natural persons they represent a juristic person, but the acts of a juristic person, it is actually a person who can also be sued and sue in a court of law. So an individual must always be seen in that light. Now, let me bring you to another part before I go straight into POPIA. Let me take you into what we call sources of law. It would not be proper for me to talk about this because sources of law are critical also. So essentially, we have said those that joined, law refers to the rules and regulations that govern the behavior of a society. And we said society's behavior needs to be governed in many areas. It needs to be governed in so far as how we relate to each other. It needs to be governed in so far as the state, how the state relates with us, so that public law, for example, administrative law, is to ensure that the state does not become overbearing. The state does not become overbearing. The state does not abuse its power. And if the state's power is not sanctioned, we can find a lot of abuse of power coming from the state. And now I'm going to go into sources of law. This is a very important part of what we do in the legal world. It's very important for you to appreciate the part I'm going into now. It's important just for you. It's important for your school. It's important for just different interests at individual, at family level, and so on and so forth. So the moment you hear the word sources of law, what we're simply talking about is, I'll give you as a question, where do you go for remedy when your rights have been infringed? Where do you go for remedy when your rights have been infringed? That's a question that goes deep into the whole topic of sources of law. So if my rights have been infringed today, where do I go in order to correct it? So there are about 6 sources of law that I'll briefly discuss before I go into POPIA. These, number 1, the first source of law is the Constitution. It is the Constitution, and the Constitution, it is regarded as the supreme law of the land. And we are here referring to Act number 108 of 1996. That's the law, the Constitution of South Africa. It is the law, it is the supreme law of the land. In fact, when we came into 1994, South Africa moved from a parliamentary to a constitutional democracy. So South Africa is a constitutional democracy, but before that, the Constitution was the supreme body in the land. Whatever the constitutional, the parliament said could not be questioned. But when we moved into 1994, it became necessary to move away from parliamentary supremacy towards constitutional democracy. So constitutional democracy simply means that any actions that are done, if they contradict the Constitution, they will be invalidated to the extent of their a contradiction. It means everything. It means even your rules in your policies in your school, and any laws that you can come up with, if they contradict the Constitution, they will be severed to the degree of their inconsistency. And I'm even talking about your will. If you draft a will and your will contradicts the Constitution at the point of interpretation, that Constitution can be severed to the degree of its inconsistency with the Constitution. I'm going to give you some legal examples so that you understand what I'm talking about. So a couple of years back when we were studying law, we would hear a particular will which was drafted in the following ways. It said, I bequeath my estate to a fund, a trust that must be formed such that when I pass away, my money must be used to educate it must be used to educate young men in further education in science that are of European descent. It actually said young males pursuing science and must be of European descent. When it came to the court interpreted that will to be unconstitutional. For instance, it mentioned that that particular will must benefit only young men of European descent, and the Constitutional Court found it to have been discriminatory unfairly in respect to gender, because it referred to young males, and then it also discriminated racially because it said of European descent, so it discriminated against other racial groupings, and so those elements were severed from that will. It had to be severed to remove the gender discrimination and to remove the racial discrimination before it could be implemented, because it had been challenged on that basis. So it means that at all levels, when you practice whatever you practice, it must be in line with the Constitution, because it is a supreme law of the land. So wills, policies, regulations, they will always be tested against the Constitution, and if they are found to contradict the Constitution, they will actually be severed to the degree of their inconsistency with the Constitution, because the Constitution is the supreme law of the land. And then let's go to the next important source of law. It is actually legislation. Legislation is a very important source of law, and these are laws passed by Parliament. Laws that are passed by Parliament, usually they are specific to a field. For example, let me give you a practical example of what this means. Take a very good example that the Constitution of South Africa, it talks about Section 23, which basically speaks about labor rights. But it is very brief. It talks about the fact that anybody who is in an employment situation must not be subjected to unfair labor practice, must have the right to form and be part of a trade union, and so on and so forth. But it is too brief. So while the Constitution makes a pronouncement, then we then have legislation, which is the Labor Relations Act number 66 of 1995, which replaced the Labor Relations Act of 1956. So the Labor Relations Act, it is legislation that governs the relationship between the employer and the employee. And it basically gives effect to Section 23 of the Constitution of South Africa. So legislation, it is put in place in order to regulate certain elements that are specific to an industry. Take NEMA, for example, which is the National Environmental Act, which governs elements to do with the environment. When you go into the Bill of Rights of the Constitution, it speaks about what we call green rights. The Constitution speaks of green rights, the right to a safe environment, unpolluted, and the like. But because it is too brief in the Constitution, NEMA had to be enacted, National Environmental Management Act. Then you have all these other acts like SASSA, South African Schools Act. We have even SACE Act itself. It governs the relationship between teachers and their professional counsel. So legislation is a very important source of law. And when you have your rights infringed, the first place you must go is to say, what does the Constitution say about this right of mine which has been infringed? And when you move from the Constitution, you must then say to yourself, what does legislation say? If the Constitution says something, or if the Constitution is silent, you must look for legislation that speak about the particular right. And that is why now we are talking of POPIA. If your right to private information has been flouted, where do you go? You go to a legislative enactment called POPIA. POPIA is the one that governs your relationship with other people or entities in respect to your private information. So legislation, it's a very important source of law. In fact, it's the second source that you go to after you have inquired with the Constitution. Now, when you move from there, so there are many other individual legislative enactments that I will not go into. For example, the Children's Act. The Children's Act number 38 of 2005. You need to know this act, especially the sections I'm typing there, section 20, section 71, section 70, as well as section 110. And section 20, section 71, section 70, and section 110 of the Children's Act, it also, you need to know that concerning children's rights, children's rights are pronounced in the Constitution in section 28 as well as section 29. Section 28 talks about the rights of a child are of paramount importance when such rights are called into question. Section 29 speaks about the right to basic education, that every child is entitled to basic education. Section 28, for example, says that every child is entitled to care, that child is entitled to a name. You have violated a child's rights if a child is born and you don't give him a name. You can actually be sued for that because you have violated the Constitution. So because section 28 and section 29 are very brief regarding the rights of a child, Children's Act number 38 of 2005 had to be enacted to give full expression to the rights of a child. For example, section 110, which ensures that you must take action to safeguard and protect the rights of a child. If you see that a child is being abused and you do nothing about it, you would have violated the rights of such child. I'm going to cite just a few elements of it so that you see them here. So Section 110 of the Children's Act stipulates that any that suspected child abuse must be reported to a child protection organization, the Provincial Department of Social Development, police, and so on. And any failure to report an abuse of a child is in itself abuse of that child. And these are parts that I'm just speaking from the Children's Act, read together with United Nations Conventions on Children's Rights, as well as SADC Convention, as well as the African Union Convention on the Rights of a Child. I was told today by the chairperson of the Council of Says, Mr. Mabudo Tele, to say that I think this week, I can't remember the specific date he mentioned today, that there is a campaign on activism against gender violence and also violence against children. So these are in advancement of the need to safeguard the rights of a child. But right now, the reason for this session is to inform you about your own rights to protection of private information, which is what I'm going to come to after I finish what I'm presenting now. So I have said, when your rights have been infringed, you go to about 6 places. The first one, it is the Constitution. The second one, it is legislation or laws. The third one, it is actually common law. Let me start with common law. So the common law consists of Roman, Dutch law, as well as English law, and which we adopted at the time when we were under the colonial era, and some of these laws, they have continued to be used. Anytime you hear that a judge is formulating a sanction or a remedy, if they fail to find a remedy in our Constitution and existing legislation, they must also go to Roman Dutch law or English law in order to find remedies. So common law becomes useful in that regard. It is also an important source of law. We also have customary law. Customary law is the indigenous law of African people. For example, the customary law of the various tribes in this country, the Xhosa, the Zulu, the Bapedi, and you talk about the Ndebeles, you can also talk about the various communities who still have their customary law, the Tswanas and everyone that I cannot mention here. So there are still customary laws being practiced in certain communities, particularly in our rural communities. And such laws, sometimes we call them indigenous laws. They are still very important, and they are also consulted. When you hear, for instance, the state versus Masokwanyane case, which is the case that outlawed the death penalty, you'll find that when the court was reaching its decision regarding this, it went at length to talk about Ubuntu, insofar as it then ruled that no one must be subjected to any degrading punishment. So this was a visitation of indigenous laws as a source of law in South Africa. And then number 5, right? Case law is very important as a source of law. case law emanates from around 3 principles that I'm going to just highlight briefly. The first one is a principle at law we call stare decisis. Stare decisis, it refers to the hierarchy of the courts, that decisions of superior courts are binding on inferior courts. So much so that if a higher court, let me use the word superior court, decision on a matter, that decision is binding on an inferior court when such inferior court is deciding on a similar issue, except only in instances where that inferior court is able to show that the case is differentiated. But otherwise, a person, let's say, let's look at it this way. A full bench of 5 judges of the High Court is a superior court compared to a High Court sitting 3 judges. And a High Court sitting 3 judges is a superior court compared to a High Court sitting 1 judge. So if 1 judge of the High Court is making a decision on murder, he is bound by the authority that is coming from a similar situation as having been decided upon by a high court where 3 judges were sitting, or even if it was a full bench of 5 judges. They always use odd numbers so that if it comes to a decision where 2 parties are not agreeing, one of the party then has a deciding vote in order to make a decision in the court. So decisions of higher courts are binding on inferior courts. And the reason why I'm mentioning this is that in a certain sense, even if the judiciary does not make laws, but they make laws incidentally, because whatever decisions they make, they become binding. So the most important thing for high courts is what we call a ratio decidendi. Ratio decidendi, it's a Latin term which simply means the reasoning that led to a judge decision on a matter. So a general man on the street, and when I say a general man on the street, don't take it as an insult. It's the language of law that we were taught to say a general man on the street does not know the law. So take a very good example that I'm going to use some awkward example. That if a person stole a cell phone of the same value in Sandton, and another person steals the same phone of the same value, let's say in Alex. Let's say they both stole a phone of 1,000 Rand. And then they sit before a magistrate, a regional magistrate, or rather just a general magistrate. And then the magistrate in Sandton gives somebody 2 years in prison, but the one in Alex is given 5 years in prison. And then someone comes and says, but this judiciary system is unfair because the person in Alex is given 5 years and the one who stole a phone of the same value in Sandton is given 2-3 years. Why? General people on the street, they are concerned with who won the case between A and B, but that's not the concern of lawyers. Lawyers are concerned with what is the reasoning that led to the decision. Because you find, for example, while a person may have stolen a phone and both magistrates are concerned with restitution, that these people must restore what they've taken from society, you will then find that maybe because in Alex, a cell phone is being stolen every hour, the magistrate in Alex is not concerned only with restitution, but they have gone into another theory of punishment called the theory of deterrence. He is not interested in only restoring what was stolen, but he also wants to deter onlookers who are also in the business of stealing phones to say, hey, you, should you steal phones, you are going to be hit with 5 years in prison, so don't do it. So that is the ratio or the reasoning that led to the difference between 3 and 5 years, because in Sandton, a cell phone is stolen maybe once in a month or once in a week, whereas there is being stolen every hour. So the ratio in Alex has to do with restitution more than just deterrence, more than just restitution. So therefore, that's why we are saying case law is very important in the making of the sources of law. And then there is also something else called obiter dicta, where a judge simply makes certain statements in passing, but they are not binding. But ratio decidendi, it is binding. It is binding in that it binds that particular case, but it also binds inferior courts when handling the same matter. I'm not going to go into this. I'm going to leave it here and then go with you to another source, which is judiciary writings or legal writings. Let me rather use legal writings of law experts. There are also binding sources of law because it's in certain points you hear when judges are speaking, they will say, I was reading a book from the learned professor so and so who said the following on this matter, and I'm persuaded by his reasoning. And you then find a judge making his decision based on the reasoning of a judge a legal writer who wrote on a specific. So all these are possible sources of law when your rights have been infringed. And you need to know this because in a certain sense, we are dealing with a law. Let me save this document so that maybe Johnson can include it among things he will send to you. What is law? Johnson, remind me. I'm just saving it in the webinar document so that colleagues who need it can have access to it. So essentially, colleagues, I decided I cannot go. I have taught law in university, and it's always very difficult for you to go straight into a particular subject without giving a background of what influences law. So in short, what I've said is that we have law as the rules and regulations that govern the behavior of a society. In order for us to have law and order, there has to be some form of laws that govern the behavior of society. And then secondly, we talked about law being divided into private law and public law. And we mentioned the fact that public law governs the relationship between the state and the individual, whereas private law governs the relationship between the individual and the state. Now, I want to go into POPIA, having taken you through what we call the sources of law. I mentioned the Constitution as a source of law. I've also talked about legislation as a source of law. I've also talked about the common law, customary law, and then we have talked about case law from principles such as stare decisis. the hierarchy of the courts, that the decisions of superior courts are binding on inferior courts. And then we have also talked about legal writings. And as a South African Council for Educators, we wish to then bring you POPIA itself. And I will switch over from the Word document into a PowerPoint presentation. And I do not guarantee you that I will finish the presentation. So if I don't finish it, everyone who's in this platform, Mr. Mangwatu, can always organize for us to have another session as a follow-up, because the principles you can see, they are as complex and they are also as demanding, and they need attention. We cannot just sprinkle over them in order for them to be fully understood. So POPIA is very critical, colleagues, in that it is a law of the land. It is legislation in South Africa. And we need to also look at the following, which are the key elements we will talk about: the introduction to POPIA, the purpose, definition, and application. And we will also go into exemptions from the processing conditions. What are some of the exemptions that you can be given when you would have processed private information? And then there is also supervision with regard to the processing of private information. There is also direct marketing, automated decisions, decision-making, and trans-border transfers, especially trans-border transactions, wherein private information can be processed. And then I'll also talk about enforcement, offenses, penalties, and administrative fines. When you wrongfully process someone's private information, you can be fined. Organizations can pay millions of dollars, rands, in order to remedy circumstances in which private information would have been illegally processed. Employment practices, we also need to talk about that. But a very important part of the world we are living in now is cloud computing. Should I have time, I'll also traverse that and talk about it. Now we'll need to talk about what is POPIA. When will POPIA become effective? It's already effective, but I'm going to talk about that. We'll also talk about what about information collected before POPIA, application of the POPIA Act, definitions, exclusions, and also exclusion for journalistic, literary, and artistic purposes. And then we also have other things we call public interest. Lawful processing of personal information. What is it? What is lawful processing of personal information? Rights of data subjects, the 8 conditions for law processing of personal information. It is my hope that I will talk about this today as well. Module 3, we talk about exemptions. I talked about that earlier. And then we'll go into supervision. Unsolicited direct marketing. Hopefully I'll touch upon that should time permit me. And then I'll talk about the code of conduct and eventually enforcement, offenses, and penalties. I'm going to talk about that as well. Now, introduction will show you that POPIA has brought South Africa in line with other jurisdictions in the world who have got similar legislation. For example, the 1995 EU directive currently under review. And then you must also know that POPIA Act places a significant compliance burden on companies, organizations, and public bodies, such as schools, people like SACE, ourselves, who possess substantial personal data electronically and in hard copy format. So you need to know that there is a significant burden on you as a teacher. I think my friend, I'll try and remember yesterday, Monday, who mentioned that it's very critical for us to know when you include children on your WhatsApp databases, among other things, you are placing yourself in a situation where you could be sued. And that is why we say it's very important. Knowing this doesn't only help you as a person, but it also helps you in your professional duty as a teacher and as a school. POPI significantly impacts on how you collect, store, process, and disseminate personal information. POPI is South Africa's primary legislation for dealing with processing of personal information. Now, if you look in the world, there are 66% of countries in the world who have private laws, such as POPIA. 10 countries with draft legislation, 19% and 10% countries, so there's 66% who have the laws. South Africa is now included in there. 10% countries with draft legislation, 19% countries with no legislation, and then 5% countries with no data. Very strange one. And if you look, the orange ones on my presentation are the countries who have no legislation, whereas the light green are the countries who have draft legislation, whereas the dark green are the countries who have the legislation. And you can see South Africa has the dark green, as well as countries such as Australia and New Zealand. You can see in the Pacific there. So it is not uncommon for a country to have privacy laws. It is not uncommon. Don't think that it is strange for South Africa to have such laws. It places significant burden on organizations, but at the same time, it protects you when it needs to protect you. So we'll talk about what is POPIA, which touches section 1 to section 7 of the POPI Act, talks about purpose, definitions, and the applications. It is the first thing you must think about. I'm going to talk about section 14 of the Constitution. I'll come to it shortly. And you must know section 14 of the Constitution off your heart. I'm going to talk about it because POPI, it gives effect to the constitutional right to privacy. Do you want to have your privacy violated as an individual? That's a question you must answer with honesty. So if you want your right to be flouted or infringed, then you do not need POPI. But if it is of concern to you that your private information will be published and it will get into the hands of people who are not supposed to be in possession of it, then you have to concern yourself with the importance of POPIA. POPI Act regulates the manner in which personal information may be processed. It provides the rights and remedies to protect personal information processed by private and public entities. That's a purpose. Now, section 14 of the Constitution of the Republic of South Africa protects the right to privacy, and I'm going to read it. Everyone has a right to privacy, which includes the right not to have their person or home searched, their property searched, their possessions seized, the privacy of their communications infringed. And then, section 15, subsection 1 of the Constitution says, everyone has a right to freedom of conscience, religion, thought, belief, and opinion. This is actually part and parcel of your rights. You have a right to privacy, for you not to be your home or yourself searched, not to have your phone communications eavesdropped into. And then data protection laws, the protection of Personal Information Act number 4 of 2013 is the primary instrument regulating data protection in South Africa to give expression to Section 14 of the Constitution of South Africa. This is very important, colleagues, and this is an important part because POPIA is a double-edged sword. It's a double-edged sword in that you as an individual want your privacy to be protected, and the next person you deal with either as a member of a public entity, in terms of which you also collect private information, you need to also ensure that such private information is protected. So this is a significant piece of legislation which is for your own good and for the good of the next person. Why is POPIA important to you and your organization? POPIA balances the legitimate needs of organizations to collect and use personal data for business purposes against the right to indicatable to respect the privacy of their private details. All organizations possess and use personal information, and therefore every organization must comply with POPIA, must comply with private information. And every organization, in a certain sense, must appoint an individual who ensures the organization is compliant. You will see when I come to that. As an individual, numerous organizations possess and use your personal information, so you need to know your rights with regard to your personal information. I'll move to the next point. So what is personal information is an important part of the conversation I'm going to have now. So I'm going to ask all of you to type in the chat room to indicate to me what is personal information. And it is illegal for you to Google at this point. All right. Give me your own understanding of private information. What is private information? What is personal information, rather? Right? Can I have one or two people share their thoughts?
Yes, Mr. Busheti, our thoughts in the,
okay. Please share with them because I'm not seeing the chat room.
Okay, we've got admin Waldorf who's saying cell phone numbers and email address. And then we've got, I think this one is Maureen's email saying I think it was personal details. And we've got Doroma Silo who's saying my confidential information. And we have got Will Batch, cell number and address. And then we've got Yolisa, who's saying information about your banking details and ID number thing or ID. My name, and we've got Nancy Broncorosbrate Primary, who's saying my name, cell phone number, and photos. And we've got Bridget Frankie, who's saying my personal data. And we've got Maureen Toava, who's saying that's any information that is private for my eyes only, unless I want anyone to know.
Okay, interesting.
Yeah.
Oh, that's a mouthful. It has to be identifiable to you. That's a very important part. So let's look at this. Private information relates to an identifiable living natural persona, where applicable, an identifiable existing juristic person, and it includes, but not limited to, the following: your race, your gender, your sex, your pregnancy, marital status, national or ethnic origin, color, sexual orientation, your age, physical and mental health, your disability, your religion and conscience, your belief, your culture, your language and birth of a person, your educational, medical, financial, and criminal or employment history, the biometric information of a person, your ID number, symbol, email address, physical address, telephone number, other particular to a person. So the private or confidential correspondence, the personal views or opinions, preferences of the person, a name if it appears together with other private information, and if disclosure of the name itself would reveal the private information about the person. So for example, if you see something that identifies me, that the moment you see it, you know this is Bernard Boucher or this is about Bernard Boucher, that information can be personal to me. The views and or opinions of another individual about a person. The views or opinions of another individual about a person. Sitting with me or with the SACE in our offices is a circumstance of a sexual video of a teacher who took some nude or rather pornographic video of herself and another party. And because of that, sometimes we do not differentiate between workmates and friends. This person accepted friendship on Facebook from colleagues at work, and one of the colleagues at work downloaded the sexual video and shared it openly in a WhatsApp group. And anyone who sees the sexual activity on that particular video knows that it pertains to teacher so and so. That's an example of information identifiable to a particular person. And that information obviously has ended up in our offices, and I'm sure it also makes its rounds in the court. Context can also be very important. A person is identified if you have distinguished that individual from other individuals. For example, Vuyo Mukwena. Then when you say Vuyo Mukwena and you put 011 2000, is that number identifiable to Vuyo Mukwena if it is actually just a general number at work? Vuyo Mukwena would be the name identifiable on his personal information, but that number may not be identifiable to Vuyo Mukwena because it is an organization's number, and nobody would really know whose organization that is if they don't know where Vuyo Mukwena works. If you then bring a cell phone of Vuyo Mukwena and you put his name together, that's identifiable to him. Helpdesk18for.com. That one cannot be private information because, I mean, no one can know what info is or which organization did it. This is. What about when you have a person like Nelson Rolihlahla Mandela? Can you call that personal information? Can you call that personal information? Anyone responds?
Yes, yes, Mr. Boucher, it is personal information.
It's personal information. And why do you say that? I think it sounds like Mr. Tolo. I can see who's speaking.
Yeah, I think we can directly link the name to the person that we know, being Nelson Rolihlahla Mandela. So in that way, it would have been used as his personal information.
It relates directly to a specific individual we know.
Yes.
Like right now, I've identified that this is the voice of Mr. Tolo.
Yes.
So if I take that voice and start using it for other things, I can actually be sued.
We've got Morinelo Dwaba.
Nelly Dwaba. Okay, thank you, Mr. Tolo.
Thank you. You know, I somehow beg to differ to say when somebody talks about Nelson Rolihlahla, that's public knowledge. It will depend what is it that I'm saying about Rolihlahla.
Okay.
Yeah, so thank you.
Nelly Dwaba is arguing to say the moment you become a public figure, you no longer have public information. Is it correct? So
let me say, I further said, I'm sorry, let me say it, I further said, it will depend on what is it said about that person.
Okay. So let me ask you a question.
I differ. I think that is personal. I do think it doesn't matter the context because that is personal. That is Nelson Mandela. It's personal. And
okay.
Can I? Yes. Can I continue?
Continue. Yes.
Yes. I say at the moment you say something about Nelson Mandela, you must understand. No matter the context, it is personal. Even though he's a public figure, it is personal. But you admit it.
Correct. So and further to that, can I start a brand of my phone and call it Nelson Rolihlahla Mandela?
I don't think so. You can't. That person, because you are selling that person's name, and that person's name is valuable. If you have a top and you put Michael Jackson's feet on it, the feet that you'll see on his albums at the back of the album, that feet is the likeness of Michael Jackson. That face is the likeness of Nelson Mandela. That you cannot use because it will impact sales, and you are abusing and you are not remunerating the person who you're using. That's it.
Correct. So if we look merely to I'm not going to dismiss your view, but I'm going to rather put it in the context of the first statement in this slide. I think is it Christos who was speaking? I didn't get to check where it was.
It's Craig.
Craig, yes, Craig rather. Thanks, Craig.
Okay.
Craig, you are correct. Meli Dwaba, you are correct in a certain way, but not with absolution. Nelson Mandela is a public figure. Nelson Mandela can get angry. Nelson Mandela has feelings. Nelson Mandela can get pain. Nelson Mandela he also wants to be private. There is certain information which if you publish about Nelson Mandela, it may not really be regarded as private information because he's a public figure, but there's certain information you cannot process. So it's both true that Nelson Rolihlahla Mandela can have private information. It's also possible that there's certain information about his name that also has a public interest. So that's why we are saying context is everything. That is why you find, for example, when parliamentarians insult each other in parliament, they cannot go and sue each other on whatever they insulted each other about outside there. They have to deal with their issues within the context of parliamentary rules. So context will always matter. If you're a public figure, you've opened yourself up to public scrutiny, and there are certain aspects about your individuality that is open to the public, and you can do nothing about it. But at the same time, there is also an extent to which you need to have your private information protected. Like what Craig is saying, a person cannot just take it and use it anyhow. Otherwise, they'll be violating that person's private information and unduly profiting from the name. So private information is bound by context at all times. Hardly are we confronted with a situation like this in real practice, in real life, but it does happen. An organization holds data in electronic format. The electronic records do not identify individuals by name, but bear unique reference numbers which can be matched to a separate index system to identify the individual concerned. The information held on electronic records is personal data. So you need to take note of this. Sometimes you can have a record which has only references, and then it may not mention a specific name, but that particular unique reference, when you match it, it will actually identify the individual. That's an example of personal data. For example, I have studied with the University of South Africa. I've studied with the University of Pretoria. If you pull out my student number and you throw it into the university systems, you can actually identify me using my student number, even if my name is not mentioned. For example, anybody who deals with my qualifications, if they take my student number and say to the university, can you please identify the records of this student number? Bernard Bushe will come out against that particular number, a number that I obtained as far back as 1997. It's still operational today in the UNISA database. So even if you leave out my name and mention the student number, there is nobody else who has that student number in South Africa. So that's an example of an index which can have reference number, but not my names, and it remains still private information. A manager's assessment or opinion of the employee's performance during their initial probationary period will, if held as data, be personal data about that individual. Similarly, if a manager notes that an employee must do remedial training, that note will, if held as data, be personal data. So as a supervisor, you cannot publish another employee probationary performance appraisal information and disclose it to a person who's not the particular employee. So if you make a note that a person needs remedial training, that is personal data which must not be exposed to a third party. If you expose it to a third party, you would have infringed that employee's personal data. These are examples. So important parties in terms of POPIA are the data subject, the responsible party, the operator, and the information officer. These four are very important, and I would have also mentioned an institution which is the regulator, which I think has been put in place now, where if your organization is accused of infringing personal information, that infringement can be reported to the regulatory entity protecting private information. And they are the ones, just like the public protector, that will come to you, investigate the matter, and charge your organization for violation of. So the data subject is the owner of the data. It is you who own the personal information. You are the data subject. The responsible party is the person who processes personal information. The responsible party is the one that gets sued, and together with the operator and also the information officer. The information officer, for example, in a school becomes the principal. In an organization becomes the chief executive officer, unless the chief executive officer appoints an information officer to be in charge of compliance elements of POPIA. So data subjects, this is a data subject is an identifiable person, a living natural person or existing juristic entity to whom the personal data relates, such as the individuals interested in the organization, its clients, customers, service providers, and stakeholders. A data subject can also be the individual, their race, their identity document, their cell phone number, their health condition, among other things. The responsible party is the person or entity that determines why and how to process personal information. That's a responsible party. So how must we and why must we process personal information? Then the operator is the person or entity that determines why and how to process personal information. I've already talked about information officer being the person who's in charge of compliance issues with POPIA. It may be the chief executive officer of the organization or anyone that has been appointed to be the deputy information officers to assist the chief information officer, who usually is the head of the organization. So look at this. Processing of personal information, it is the manner in which we collect, receive, record, organize, collate, store, update, modify, retrieve, alter, in consultation or use personal information, whereas dissemination also is when we transmit and distribute that information. You find many organizations have been in charge of databases where they keep a database and do direct marketing. That now is regulated by POPIA. A person who just calls you and start marketing things can actually be sued on the basis of POPIA. Because the first question, how and why did you get my personal information without my consent? Dissemination by means of transmission, distribution, making available in any form, which may mean merging, linking, erasing, and destroying information. If you have someone's information and you destroy it, you can actually have processed that information either legally or illegally. So it is mostly what we do with personal information in our possession, or what an entity does with personal information of people that is in its possession. It's very important. So it's about how you collect, how you store, retrieve, retain, or destroy or use personal information. There are rules governing how you must process. And this is the processing cycle that I just posted there. So any recorded information, which could be in writing, electronic information, labels, markings, images, film, map, graph, It could even be your tattoo, a drawing, a tape, in the possession or under the control of a responsible party, whether or not it has been created by the responsible party. It doesn't matter how it came about, but the most important part is that that information is in the hands of a responsible party. The responsible party is the organization that's processing that information, which could be a private, a public body, and it determines how that information is kept. Take an example. A network of town center CCTV camera is operated by a local municipality jointly with the police. Both are involved in deciding how the CCTV system is run and what the images it captures and are used for. The municipality and the police are jointly responsible parties in relation to the personal data processed in operating the system. So if you have your CCTV and it captures my being as I pass by, you are responsible parties with respect to how you process the images that CCTV camera captures. You are actually in possession of my personal data. I'm just giving this as an example. Even yourself, when you pass by a certain place, your images are captured by a CCTV camera. That CCTV camera, if it's operated by police together with the municipality, they are both jointly responsible for the processing of personal information. It's very important. Other key concepts includes consent. Consent means any voluntary, specific, and informed expression agreeing to the processing of personal information. This is why we are saying we recommend every school to go and revise its forms or put together another process in place so that you can obtain consent from people in order to process their information. So consent, it is should not only be given, you must show evidence that you obtain the consent. If you have got a form that captured my information, but on that form, I do not show you that I agreed to you processing my personal information, I can turn and sue you for processing my personal information. Doesn't matter 1,000 reasons you can cite to say, but you signed. As long as I did not consent, I didn't provide you consent to say that I consent to you voluntarily, and I'm giving you an informed expression for you to process my information, it can be tantamount to a violation or infringement in respect to the processing of personal information. So the data subject means the person to whom the personal information relates, and the data subject is the one who must consent, who must do so voluntarily. They must not be compelled. They must not do it through compulsion, but they must be consenting. They must be specific and providing informed expression, giving you the power to process their personal information. The identity means to delete any information that identifies the data subject or can be used or manipulated to identify the data subject or can be linked to other information to identify the data subject. That's the identity. When you destroy personal information you previously took of a person, you need to do it within lawful and justifiable reason. Now, I'm not sure if I have time, Johnson. I've got 17 minutes left. Maybe let me just address one or two things and then I'll close it. And I will say to Johnson, please arrange another time when we can continue the presentation. Because I also want to give time for any questions so far. Application procedures are very important. POPIA applies to processing of personal information. We've talked about that. Of any responsible person domiciled in the Republic. By domicile, we mean that a person who is ordinarily resident in South Africa. POPI will override other legislation that contains inconsistent provisions relating to the processing of personal information. The same way we mentioned that the Constitution will invalidate anything that contradicts the Constitution to the degree of the inconsistency. If other legislation provides for more extensive conditions for the processing of personal information, private information, the other legislation will prevail. But if that legislation is inconsistent with POPIA, it will then be regarded as inconsistent to the degree of the inconsistency and must be brought in line with POPIA in respect to the processing of personal information. Here are the rights of data subjects. They have a right to object on reasonable grounds shown to the processing of their personal information. Number two, they have a right to be notified that personal information has been accessed or acquired by an unauthorized person. So, for example, if you are an organization and you're holding my information and a person accesses that information without my authority, I have a right to know that. You must inform me. For example, if you experience a hacker or someone that violates your information, the organization that holds that information must inform you, be it a bank. The bank must inform you that our systems have been hacked and your information has been accessed or acquired by an unauthorized person. And they also must account for how that has happened, and also you have a right to sue. You also have a right as a data subject to establish whether a responsible party holds personal information and requests access to it. It's important to also request the correction, destruction, and or deletion of your personal information or request access to it at any given point in time. That's your right as a data subject. You also have a right to the correction, destruction, or deletion of your personal information. It is a right of a data subject. That applies also to your students. Your students have a right to have their information corrected, destroyed, or deleted. It is their right. It's a right provided by POPIA. Now, there is information which is excluded. POPIA excludes processing of personal information for purely personal or household activity, or information that has been de-identified to the extent that it cannot be re-identified again. So if information of a person has been de-identified and there is nothing that can make that information re-identified again, it is excluded from the ambit of POPIA. POPIA also excludes by or on behalf of a public body information possessed by or on behalf of a public body. So, for example, if information is possessed by a public body or on behalf of a public body, it is excluded from POPIA Act restrictions, especially information which involves national security, or the purpose of which is the prevention, detection, investigation, or proof of offenses. Now, many people would say that it is your personal information, but the moment you have violated the law, then we bring another issue which is very clear in the Constitution of South Africa, that certain rights are limited. We actually call it the limitation of rights. So if a person has committed an offense and we want to prevent, detect, investigate, and provide proof of offenses, that information is excluded from the provisions of POPIA. And then also, POPIA excludes processing of private information solely for the purpose of literary or artistic expression. to the extent that the right of privacy is balanced with the right to freedom of expression. We will need to qualify statements like this because they are loaded with, they are pregnant. So there are certain literary and artistic expressions which are excluded. For example, a person who imitates the voice of Mandela in a comedy, this person has expressed certain information. Take a very good example in South Africa of our own Trevor Noah, who is able to imitate Nelson Mandela. The moment he imitates, that information is excluded from private information because it is a literary and artistic expression, and it is balancing privacy to the right of freedom of expression. So there are many examples I can give you regarding that. An individual keeps a database of their friends and relatives, names, address, dates of birth on their PC. They use the database of keeping track of birthdays and to produce address labels for Christmas cards. The domestic purposes exemption applies to this type of information. So you cannot sue your friends for having, or your relatives for having your addresses and your phone numbers and your names on their PC for purposes of celebrating your birthdays, for possessing that information, because there are people within a reach of your private self. As an example, and I hope we understand. Johnson, I don't want to go to chapter 3, which speaks to conditions for lawful processing of personal information. I think I want to challenge you to say, let's deal with this in the next session because our time is up. We're almost nine minutes left. Let's leave it to question and answer. I'm going to rest my case for now. Thank you very much. All right, let's then give opportunity. I think I see my friend Memory there. Hand is up. I'm not sure if there's anything from the commentary. Memory, I think let's give Memory a chance to speak, and then we will move to other persons. Thank you.
Okay, thank you. Good afternoon, everyone. I want to ask, you have raised very good laws that we tend to look, we overlook, okay? There are things that happen in institutions. For example, if after an interview, someone who is part of SGB comes out and say, so and so could not answer the questions, was or maybe could not speak English properly or could not. One, is that not bringing out information, personal information for that person who was being interviewed? And then secondly, another question is, if you are a manager or you are someone who keeps information for people, and then maybe I give you my 6th certificate and then I find it lying on your table, it's not filed, not put in somewhere, is that not revealing my my private information? I just want to ask those two questions.
Thank you very much. Let me also give it to my friend Craig.
Hi, good day, colleagues. Good day, Bernard. How are you doing?
Very well, Craig. Very well. Thank you very much.
Yes. Thank you for the information. I would like to just give an idea on the fact that the stuff that you talked about, it actually based down to when you construct a code of conduct for children's behavior or for the participation of the community or parents. I just want to say that a person should really take into account the things that you said, that whenever you construct as a school a code of conduct, it is imperative that it is in line with the Constitution, that it's in line with legislation, that it's in line with the Children's Act, or even go so far as saying that it should be in line with the United Nations policies. So whenever you have or design policy that protect your children, your organization, especially in our case, our school, you need to ensure that your code of conduct, that whichever policies you create, design, it needs to be in line with the constitution, with legislation, and all the things I've just named. Yeah, so that is just something I want just to give that idea how imperative it can be in contravention ultimately of the most important things, and you can actually be sued because you failed to actually take into account all those acts that is in the constitution, etc. But thank you about it.
Thank you so much, colleagues. I'm going to start with memory. Definitely, the SGB is a responsible party. It's very important that the actions of the employer are in line with the Constitution. Remember, the very first place you violate when you publish somebody's private information to parties who must not have access to it is Section 14 of the Constitution, which I mentioned. You have a right to privacy, memory. And if SGB is to publish that a person could not speak English in an interview, they are actually violating the person's private information. And if I was one of the people whose such information is published, I can sue such SGB through the regulator. And look at this. There is another law which is very important called the law of delict. Because once your private information has been infringed, it is regarded as delictual injury to your name. It is now going to be pursued on the basis of the law of tort or the law of delict. And the SGB, being a representative of the employer, can be held vicariously liable for its actions that violated your right to personal information. Now, look at this very carefully. I'm going to give you a rather remote example, but it's very important for you to look at it from the perspective of it's applicable in the circumstances I'm talking about here. And I'm talking essentially about vicarious liability. Remember, there is direct liability that every person is responsible directly for their own actions. But an employer can be indirectly liable for the actions of its employee. So in London, here is what happened. This is a case law which is used everywhere. You know, in London, motorists usually do not get out of there. In fact, filling stations don't have fuel attendants. So you go in, you pay your coin, and you pour your own fuel. So at a particular filling station, there was a young boy who used to stand there, and he would receive a coin from a motorist, put money in the machine, and then he will pour fuel on behalf of motorists, and they'll pay him something in return. So on a particular day, this young man was smoking a cigarette, and he didn't put it out. And that cigarette then, he didn't put it out correctly. Let me say it that way. And the cigarette then went and lit the filling station, because remember, it's an inflammable area. So the whole filling station blew up. And the problem was not the blowing up of the filling station. It is when the fire extended to neighboring organizations. So these organizations sued the filling station, and then the filling station claimed and said, but this was not their employee, it was just a street boy who was assisting people. But then the court asked them very important question to say, how long has he been doing this? And it emerged this young boy had been doing it for over 3 years. The court said, but whose instruments was he using to pour fuel? They say it was our instruments. So he says, when it suits you people, you disown him. But when there is trouble, you disown him. Because by reason of you seeing him assisting your motorists and you did not do anything to remove him from doing that, by default, you employed him. And therefore, you are vicariously liable for his actions or inactions that have led to injury of the filling station. So that's an example of how an organization can be sued for the actions of its employees. During my law school, I did a number of cases where, for instance, a couple of years ago in Eastern Cape, the Minister of Police was sued. I think at the time it was the Minister of Security who was in charge of police, was sued because one of the police officers raped a young lady while on duty. And even if the minister argued to say when the police officer was raping this young lady, he had gone out of the duty of the employer into self-gratification. But then the court, especially the Constitutional Court, then said, but what is the role of a police officer? It was to protect members of the public. So while we can look at the issue of commission, what was done, which was outside the law, but we also look at what was not done, which was acts of omission. So vicariously, the minister was held liable. So I'm bringing it then into context. An SGB is a representative of a school. Once that SGB member publishes private information of a person in the result causing injury to that person, then the employer or the school which is issuing that SGB member will be held vicariously liable. What it will do with the SGB member is up to it, but the school is the one that gets sued for publishing private information. That is an extent to which it violates a person and causes injury to their name. So I hope I've answered that to memory. And then when it comes to a certificate of a teacher given to a principal, puts it on his desk, a desk which is an office which is frequented by people other than that teacher, you are actually exposing private information which must not be consumed by other people or persons other than the person who is the owner of that information. And that's actually a violation of private information in terms of POPIA. So you need to watch out on that. And then coming to Craig, it is very important that when we actually come up with codes of conduct, rules and regulations and policies, we make sure they comply, first of all, with the Constitution. Remember, POPIA is informed by Section 14, which affords everyone a right to privacy. So you then need to ensure your codes of conduct for students, for teachers and everyone, it actually gives expression to the right to privacy. And if that is legislated by your school, lining up with Constitution and legislation, it ensures that then you are safeguarded should any infringement arise. It also ensures that your educators, when they process private information, they comply with Section 14 of the Constitution, read together with POPIA number 4 of 2013. So it's very critical, Craig, the point you have raised, and we need to take cognizance of these things. Let me open up for any other question now, if there is any other question. But colleagues, this is a conversation we need to take further other than just this session. We need to have more sessions on this. Let me have Annelie, and then we have my friend Mr. Tolo there. Annelie, please unmute. Annelie. Annelie, unmute and speak. Annelie seems to be having a challenge. Let's have Mr. Tolo for now while we wait for Annelie to come on board. Mr. Tolo, you can unmute and share your thoughts.
Thank you very much, Mr. Boucher, for a very informative session. May I also add by saying ignorance of the law is not pardonable but punishable. And most of us, teachers, officials in the districts and province, we are likely going to be found wanting for infringing the rights of the people that we serve in terms of us holding their personal information. I would refer this to our open plan kind of a situation, wherein you are employed maybe in the HR department, you are expected to process this and that information of educators, and you'd find that the files are lying there and the offices are accessed by individuals from one office to another. That on its own, to me, it's going to create a serious problem for us. Even at SAIS, I've seen that they are working at an open plan kind of a situation, so you are not immune to this one. My addition again would be, Mr. Boucher, share your thoughts on this one. How is the rights of learners limited on a section, I'm not sure as to whether it's 28 or 29, which says in every matter that involves the child, the rights of children are of paramount importance. I'm referring this one to a situation where you'd find that at a school level, we've got these teachers who remember, children have got the right to be taught. And you will have teachers who would want to just go to a school and be present, but they are literally absent from school. So if we say in every matter that involves the child, their rights are of paramount importance, then the limitation thereof, as well as the limitation of this educator who doesn't want to perform the duties as per the contractual obligation, where do we draw the line there? Thank you very much.
Thank you so much, Ntate Tolo, for that comment. I may have missed some part. I was about to respond to. I saw a comment. I think Mr. Mangwato is no longer in the session. Alfred, I was almost responding to Alfred to say, may a school hand over personal information of parents not paying fees. But let me just hold on for that. Let me come back to Mr. Tolo to say, please rephrase your question. My apologies regarding the rights of a child, section 28 element, so that I can respond properly.
The section says, in every matter that involves the child, their rights are of paramount importance. Mm-hmm. Now I'm saying, in terms of section 36 of the limitations of rights, where do we draw the line there? And I'm also coining it up with the educator who is always at school, but literally absent, but he's present at the school, but physically he's present, but he's literally absent because most of the time this educator is banking classes, doesn't want to go and deliver that which he is expected to do, and he is not responding to his contractual obligation. Now, my question, based on the paramount importance of the learner's rights versus educators who are just there, where do we draw the line?
That's a very complex question, Mr. Tolo. I deliberately will not respond as extensively as you want, but I know exactly what you are talking about. Remember, this is a question bordering on the conflict of laws between section 23, the right to labor rights, as well as the right of a child. So as we speak, it's an area that I can say to you that needs a lot of, there is a Dr. Yaku Deacon, who is the Chief Executive Officer of FedSAS.
Okay.
He wrote a paper on the balancing the right to strike and the right to unqualified provision of education to children. And I'm going to avoid this question today, Mr. Tolo, and maybe let's indulge on it in the next session.
No problem.
Because if we are going to do so, I can guarantee you we are going to have an unending debate today. But maybe let's indulge on it in the next session at the early hours of its engagement. But the few comments I can give you is that there is definitely a contradiction in respect to the fact that the rights of teachers to strike are rights which are critical in the Constitution, but then the rights of a child are of paramount importance. The child must be taught. And then it is bordering on the conditions under which the child must be taught. And I know SATU comrades, NAPTOSA comrades, and SAOU comrades will definitely come guns blazing on this one. So I will rather hold on to it, but I'm going to definitely give you my expert opinion on it because it's a subject of my interest currently. I'm actually studying it very closely, and I think you can pick that I'm at home with the issues.
Okay.
Yeah, but let's entertain it in the next session. But it's a critical question. How do we balance the right, the unqualified right of a child to basic education and the right of a teacher to strike in protection of their labor rights? How do we, because the labor rights are unqualified, are qualified rather, and remember also labor rights, they go as far as we're not only talking of the Employment of Educators Act, we're also talking about the issue of collective agreements governed by Section 50 of the Labor Relations Act in respect to bargaining councils. In fact, Section 37, subsection 2 on bargaining councils, among other things. But let me not entertain this one for now. Then, Alfred, your question regarding submission of names of parents to a debt collector. You can actually submit names of parents to a debt collector, but you must show that you would have talked to such parents and communicated with them and informed them of the need to do that. And that information is, and also the most important thing, colleagues, you must picture with POPIA. POPIA is about you processing this information in a lawful manner as well as a reasonable and fair manner. And those are the things that I also want to touch upon in the next session. It's unfortunate our time is gone and I cannot adequately respond to some of the questions.
Mr.
Okay,
Mr.
yes.
Sorry. I think the previous speaker, his question, I would want to relate it to a teacher who is present at school and he said banking a lesson, it means you are there at school, but you are not attending your periods.
Yes.
Yes.
and you
and
realize
this is not a strike. This is not a strike. You have signed in and you are there at school, but during the lesson you are not there in class, and it happens in schools.
If it happens in that way, it borders on labor matters. And I think Mr. Murwasi, I can see his head somewhere. I think I'll ask Mr. Murwasi is the manager for legal and ethics at SACE, and I want him to also, because he's a seasoned lawyer, I also want him to come in and comment on this one, but it's a labor matter. But Mr. Murwasi, please do us a favor on this one. Maybe before Mr. Murwasi, you come in, let's allow Dudu to share thoughts. That's Mr. Murwasi there. Dudu, share your thoughts so that Mr. Murwasi can tackle them both.
Okay, thank you, Ntate Pusha. You know what, at school, we usually have the attendance register and also the period register. If you didn't, yes, if you didn't go to class, we trained our class rep to sign the teachers who attended their period. Then if the teacher didn't go to class, then the class rep is supposed to write absent. Then after school, you collect those attendance period registers to you, and also you control them. There is a guide that we use to control those attendance period register. If you find out that there was a teacher supposed to be in class, then tomorrow morning you call that person and said why you didn't go to class in this period. Then that person must explain in writing and also come up with a covering plan, because learners, they are there, and also we need to put the time on task and task on time. Thank you, sir.
Thank you so much, do for that. Mr. Murwasi, you can come in.
Thank you and good afternoon, colleagues. Pardon us, it's already late, but let me ride on what Mechabe said, because that's exactly what I was going to say. Colleagues, when you take up employment, you say to the employer, I will give you my time and I will deliver to the best of my ability, and I will empower my learners. And being in school, your body is there, but your mind is elsewhere, and the learners are failing. That is tantamount to misconduct. So the procedure mentioned by Mechabedi would work best to say we ought to monitor. It doesn't help being in school and you're busy with your assignments, you are getting your master's doctorates, but your learners are failing at the end of the day. It simply means that you are stealing your employer's time. You are not serving the purpose for which you said you are there for. Therefore, an educator ought to know that that is misconduct, and when reported, they should not complain, because we are failing the system, we are failing the chain, we are failing the team. So there has to be systems in place, as Mechabedi has said, to say that there has to be a way to control those, and I think having such registers as per Mechabedi would assist. So that is misconduct, being there but not executing your duties. That's actually what we call indolence.
Thank you very much.
Thank you so much, Ntate Murwasi, for that. It's actually a violation also of the Code of Professional Ethics of SACE, and it's improper for teachers not to execute their duties. Let me also have, I think my friend Chabedi also had his hand up. Chabedi? And Craig as well.
Evening, colleagues. Hey. Okay, I think this one needs to be addressed in the next session, the devotion.
Okay.
I'm having a challenge with learners given the duty to monitor the educators. In a way, it seems like someone is not doing his or her work. So they delegate students, and I just wish that that can be discussed in the next meeting.
I think we have to touch upon it when we talk about the role of the SMT. Thanks, because SMT is the one which must supervise the conduct of teachers in classes.
Yes.
And it's part and parcel of the teacher's rights, responsibilities, and safety to say, when SMT doesn't do its duty, it's very possible that children can become indisciplined when teachers don't do their part, and we end up with some of the crises we're having in schools.
So, just a minute, and earlier this year, that exercise was tried in our school here. So I entered in the class at 1 o'clock, and then the learner wrote 13:30 in front of me, and I was on time, so I managed to attend to that on time to say, Sisi, this is not how it's supposed to be. So it causes some sort of confusion, if not a misunderstanding between the teacher and the students. So my wish is that someone must do his work. That's it.
Correct. So we have to be diligent, colleagues. It's in a certain sense we need to protect the profession and ensure that the profession does not come into disrepute through inactions or actions, and so on and so forth, like what also Mr. Murwasi has indicated, indolence and the like. Colleagues, our time is fast spent. Craig, Craig, I had forgotten Craig, my friend, sorry. Craig, please come in and comment. You had your hand up earlier.
Yes, I am here, Bernard. As you said, this is very complex because on the one hand, you have the law that protect the child, but then you have the law that actually protect the educator, the teacher, the laborer. And to me, these kind of things has got so much dynamics and context that this is something that should be left to the systems that deal with labor, that deal with the child's rights, or with systems of intervention where a person is actually held, where you are actually looking at what's happening. So yeah, there's so many dynamics, there's politics, and this is something that has to go through the processes that is guided by the systems, as you have mentioned. Yeah, so there's much more to than just saying it. It needs to be investigated. There's a lot of things here. So I agree with you. You can't just say a no or a yes or whatever it is. This is too deep. But something important that I remembered you said, Bernard, you actually said that we must be careful with our forms. We have to go and change it. It is true. You see, we have this thing now, the cell phone, and we want to actually show parents in the communities how the children are doing well. We want to make the video. We want to take the photo. We want to, we're enthusiastic. And now with the pandemic, the COVID, you don't have that one-on-one as you had with your parent meetings, blah, blah, blah. The point now is that you use the cell phone. And very important is that if you take photos of a child, even of an activity, and you have not created a form that actually give consent, the institution, the government, the individual, the school can get in big trouble. So that, I think that to me hit home, and that's what we need to go back to and go tell our schools to ensure that the consent, even for just a simple photo of the child or the situation, the clip, the video clip. Thank you, Bernard. Thank you, colleagues.
Thank you so much, Craig, for that. Definitely, we need to move in as schools. We need to be diligent and ensure we are not only protecting the right of a child to basic education, but at the same time, we're also protecting the profession from being reviled because people don't take the teaching profession seriously because of one or two elements. But at the same time, the principal, the SMT need to do their part extensively. When a principal does not do his part, I think maybe Ntate Murwasi also take opportunity to just briefly before we close, comment about what just happened in Eastern Cape, including the one that you spoke about earlier this morning, and the role of educators.
Thank you, colleagues. Colleagues, you may have heard or may not have heard that we are sitting with two deceased learners. May their souls rest in peace. And in all instances, this what happened brought along negligence of teachers. On Friday last week, a learner came to school to write exams. At 11 o'clock, she tells her friends and teachers that she's not feeling well. She's got a severe headache. She kept on going to teachers to say, I am not well, but they ignored her. At 13:35, the learner died. The school is situated less than a kilometer away from hospital with very busy transport. I don't know how those teachers are going to explain not having listened to this child. On the same token of breath, you may have heard of a learner who committed suicide also in this past week in the Eastern Cape also, having informed her teachers for over a year She mentions 3 specific teachers in her voice note and to friends and so to whom she's been reporting to say that I am being bullied, and it's because she's got a spiritual gift, and she's being bullied, and the same teachers began to ostracize her and also began to bully her and named her names and so forth, to such an extent that she ended up taking her own life. I don't know how those teachers are going to explain not having protected this child, more so that it was over a year. She's been reporting to them consecutively for over a year of her challenges, but they ignored her. Instead, they labeled her. So colleagues, we're just saying we know teachers are busy, but we need to at least just give them an extra minute just to listen to their problems. They are belabored much as we are. You know, they do come to you and they tell you all sorts of things. Just give them just that extra minute. We wouldn't be having a dead child or dead children on our hands, but it is there. It is what it is. Somebody has to answer, and that is nothing but negligence, colleagues, gross negligence. So it's a plea to say, let's try. We know we are busy, colleagues. Thank you.
Thank you so much, Ntate Mruasi, and those are painful situations we have on our table, and yeah, very sad. But thank you for giving us the update, Ntate Mruasi. We'll update educators in the next webinar on Monday. Mr. Mangwato, I'm not sure if he's still on the platform, but yeah, that is it. Colleagues, I think let's. Is Mr. Shikombana on the platform? I don't think so.
I'm still here, Mr. Boucher.
Oh, you're here. I thought you were no longer there. I haven't seen you in a while. I want to check if it's proper for. Did CEO join? Any?
Yes, always in the platform. Yes. Maybe you can just. Yes.
Oh, CEO, let's ask our CEO to also just say hi to colleagues. And obviously she might also want to comment. Colleagues, when the CEO joins, it's always a pleasure to us because she's one of the champions of education in South Africa. It also gives credence to what we are speaking. She was actually talking about this in Parliament yesterday. She was in Parliament yesterday and also in council today that we have these webinars and trying to empower the teaching profession. CEO, please just say hi to the educators before we close.
Thank you very much, Ben, and well done to the session. I can see the colleagues are really feeling empowered and the information is really valuable. But just to say thank you to yourself, Ben, and the team in the office, but most importantly to our esteemed educators, because this is for you, this is about you. If we are not capacitating you, empowering you, and learning from you, then we are not doing our work. And therefore, we appreciate the fact that you take your time after school to really participate in these sessions, empower each other as well, and learn from each other. They say in the 4th Industrial Revolution and changing times, education, empowerment, development, training, skills development, capacity building takes place anywhere, anytime. And therefore, we appreciate you. Even in future, continue to invite the colleagues back in the schools so that we don't continue to have some of these mistakes and also the ignorance of law, as one of the colleagues has already indicated. So thank you very much, Ben, and the colleagues.
Thank you so much, CEO. We appreciate you encouraging us. Colleagues, that was the CEO of SACE, and also it says what we are doing is within line that and that's a vision she shared with us beginning of this year to say, guys, let's stop the issue of educators coming and begging, looking for us. Let's take SACE to educators. That's what we are doing now. On this platform, we have even assisted some educators to have their registration issues resolved, among other things, apart from ethics issues, as well as now we are dealing with personal life issues. And we also thank Mr. Mangwato for being resilient and ensuring these sessions are taking place. Mr. Mangwato, I think we are done, unless you have any other announcement, and also share the register with colleagues. But colleagues, I think for today, let's end our session here. We have already gone a lot into it, and these are sensitive things that we need to discuss extensively, but Johnson will share with you when we will do a continuation. It's important that we do the continuation to look at other sections of the POPIA and complete it. But schools also, please go in and revise your policies, your codes, and so on. Even the educator who asked to revise your fees policy and ensure when parents are signing them, they are actually signing to the extent that you may give their names to debt collectors. If you do it at an inception level, or even if you revise fees policies, get parents to sign and ensure that POPIA is incorporated. Thank you very much, Mr. Mangwato. I leave it to you. From my side, I am done. You can close the meeting.
Oh, thank you very much, Mr. Bushe. I think we will meet on Monday, and I would like to thank all the colleagues who joined today. And I hope we all sign the register, and then in that ways I can say good night and have a nice evening too.
Night, and thank you.
Good night, colleagues.
Hey, colleagues, thank you, SACE team. Till we meet on Monday. Thank you for the wonderful presentation. I've learned a lot about policies. Thank you.
Thank you so much. Thank you so much.